we doing, Judge?
Good to go. And we're online on the other program.
Okay. Step up here, state your full name for the judge, sir. Step forward. There you go.
Roque Barraza,
All right, sir, do you have a middle name?
um, Ramos R.
Okay. All right. The state's alleging two charges against you. Both of them are felony allegations. The first one is dangerous drug possession or use. The second one is drug paraphernalia possession or use. On those charges, you have the right to remain silent, right to counsel, and right to trial. I've scheduled you for a preliminary hearing on the 27th of November at 4 o'clock p.m. The preliminary hearing is to determine if there's probable cause to charge you with those two felonies, not convict you. If probable cause is found, your case will bind over to the Gila County Superior Court, and they'll take disposition on the case. If probable cause is not found, then the charges could be dismissed. There's also a possibility that the case may go in front of a grand jury. At this time, we don't know if it will. So you're ordered to appear on that date and time. If the case does go to grand jury, you'll be notified by mail to your address that you do not need to appear. The safest thing to do is to call the first business day before your court date and find out if it's still proceeding. Okay? Your release conditions are as follows. Obey all orders of the court. Do not commit any crimes. Notify the court immediately if you change address. Do not leave the state of Arizona without permission of the court. Do not possess or consume any alcohol or drugs without a valid prescription. And do not possess any firearms. Can you understand those release conditions?
Yes, sir.
Can you obey them?
Yes.
And you'll show up to court unless you're otherwise notified?
Yes.
Okay, I'll release you on your own recognizance. Do you have any questions?
No, sir.
Okay, that'll be all then.
Thank you.
You're welcome.
Thanks, sir. Step up here, state your full name to the judge.
Your Honor, Conrad Lyle Begay.
All right, Mr. Begay, give me one moment. The state's alleging one charge against you, and that is driving on a suspended, revoked, or canceled driver's license. Additionally, there's civil traffic violations in there. One of those civil traffic violations is no insurance, and the other is no registration. On those charges, you have the right to remain silent, right to counsel, and right to trial. What I would like to do with your permission is, instead of having you come back to court at a later date and drive from New Mexico, is hold your arraignment now and take a plea from you on the criminal charge and possibly the civil charges. To do that, I would have to get your permission to waive your personal appearance in front of me and do this by video. Do I have your consent?
Yes, Your Honor.
All right. So the driving suspended violation is a Class 1 misdemeanor that has a maximum fine of $2,500. 6 months in jail, and or 3 years of probation. That's the maximum. There is no mandatory minimum, so the court has the discretion from 0 up to the maximum.
Okay, Your Honor.
Your options are to plead either guilty, not guilty, or no contest. The difference between a guilty plea and a no contest plea is the following. If you plead guilty, you're admitting to the facts of the case and acknowledging that you committed the violation. A no contest plea means that you're not admitting to the facts, nor are you denying the facts, but accepting the conviction. Both guilty and no contest show on a criminal record and go on a criminal history. Okay? The other option is to plead not guilty. If you plead not guilty, that means that you're innocent of the offense, or you wish to speak with the prosecutor. I just need the record on it. Or you wish to speak to the prosecutor. What would happen is we would set up a pretrial conference date, and you would have to come to Payson, or you could do it telephonically. I could grant that permission. And you would have a discussion with the prosecutor. At the conclusion of that meeting, one of 3 things would happen. 1, the case would in fact proceed to a trial at a later time. 2, the case could enter a plea agreement. Or 3, the case could be dismissed. Do you understand that?
Yes, Your Honor.
All right. You also have the right to an attorney. There is no jail time being asked of this case. So whether you plead not guilty and go to trial and are found guilty, you are not facing any jail time. Or if you plead guilty or no contest, you're not facing any jail time. Being that there's no jail time, it removes that ability to have a court-appointed attorney. So your choices are to hire an attorney at your own expense, or to waive the presence of an attorney and proceed forward regarding the case. You understand that? Let me explain it to you again.
Okay.
So right now, if you have an allegation of driving suspended, the court cannot provide you an attorney free or to little expense because there's not jail time.
Okay.
Okay. There are other reasons why you could qualify for a court-appointed attorney, maybe like a mental disability or something like that. So
Okay.
if you have a qualifying reason that you can make known to the court to see if I can appoint you a court-appointed attorney at little or no cost, then you need to let me know of that reason. If you don't have any of those reasons, you're then faced with 2 choices. Number 1, hire an attorney at your own expense, or waive the presence of an attorney and proceed forward with your plea.
Okay.
You understand that now?
Yes.
All right. Regarding the attorney, do you wish to give me a reason to see if you qualify for a court-appointed attorney, or do you wish to waive the presence of an attorney, or are you going to hire an attorney at your own expense?
Then no attorney.
Okay. What I'll do, sir, is send you a form that waives, number 1, your personal appearance that we spoke about earlier,
Okay.
and then number 2, waiving the presence of an attorney. So that one form will cover both, requires your signature.
Okay.
All right. Do you have any questions before I take a plea of either guilty, not guilty, or no contest from you?
No.
Okay. How do you wish to plead to the charge?
I'm guilty.
If you have questions, I know you kind of said that with some pause. If there's any questions that you have, I'll answer them for you, and I want to make sure you're clear about what you're doing. So guilty means you're admitting to the violation, and we'll get ready to move to sentencing right now and get this thing wrapped up, okay? If you're not sure about that or unsure, then I can enter a not guilty plea. That gives you time to think about it, number 1. And then number 2, you would have to come back and speak to the prosecutor to see if they're going to offer you something or they're not going to offer you anything, and have to set a trial. If you go to a trial, you will have to appear in person on that.
Okay.
Okay? Or you plead no contest, which I explained the difference of that and guilty.
Yeah.
Are you sure
Okay.
about your guilty plea?
Let's do not guilty, sir. Your Honor.
All right, so what that means is I'll set you for a pre-trial conference, okay?
Okay.
That gives you an opportunity to think about it a little bit.
Okay.
And then by the time I give you your next court date, which will be December 16th,
Okay.
at 2:00 p.m.,
Okay.
you'll have the ability to, figure out what you want to do. If it's possible that you can get your driver's license back between now and then, absolutely do that and bring it with you, and that may help you in that plea agreement. I don't know. I can't speak for the prosecutor, but I've seen sometimes where that's beneficial.
Okay, thank you for the advice, Your Honor.
Yes, and then I'm also going to allow you to, so I gotta clarify that, it's not advice, it's just information.
Okay, yeah,
Yeah,
okay, thank you, sir.
I can't give legal advice, but all right, sir.
you.
So I'm going to also allow you to appear telephonically on that next hearing since you're out of New Mexico.
Okay,
So
great.
I'll send you instructions on how to appear at that next court date. It's going to require you to call before your court date and have the number and information so you and the prosecutor can kind of figure out the direction of things are going to go. And then on that actual court date, you can appear telephonically to that as well, and we'll be informed of what's happening with the case.
Okay.
Do you have any questions?
No, Your Honor.
All right, that's all I have for you, sir.
Okay.
Autumn Green.
Yes, can you step forward a little bit? Thank you. And state your name, please.
Autumn Green, living person, not the entity.
All right, so your name one more time. I'm sorry.
Autumn like the season, green like the color.
Okay, and the middle name?
Lynn.
Okay, any other names? Okay. The state's alleging one charge against you, which is driving on a suspended, revoked, or canceled driver's license. That's a class 1 misdemeanor. You have the right to remain silent, right to counsel, and right to trial. What I'd like to do is go ahead and move forward into the arraignment and take a plea from you today. To do that, I need your permission to not schedule another day where you have to come back to court, where you have the right to personally appear in front of me. So what I'd need you to do is waive your personal appearance and go ahead and move forward by video. Do I have your consent?
So would that be a no consent to move forward, or?
It's consent to do this by video instead of scheduling you back to another court date where you have to come in person. So I'd like to handle the next proceeding right here, right now, by video for your convenience. So it's one less court date that you would have to one less to come to.
I guess so.
Do you understand what I'm asking you?
Well, I still have to come and see you either way, so.
You do?
Case.
Oh, okay. Yeah. So particularly this case is all we're talking about.
I guess just do it by video since I'm already here. So.
Okay. So you're waiving your personal appearance as far as this case goes, and we can move forward by video.
I guess so. Yeah.
Okay. We're not going to do it because when you say guess, you're not clear. Or you don't understand. So.
I'm trying to understand That's
Yeah,
a
so
lot
I'll,
better.
I'll answer you any questions. What, on this case only, don't think about any other cases, okay? This case only is a driving suspended, revoked, or canceled. What I'm trying to do is waive your personal appearance and have you scheduled back into court at a later date. I'm trying to save you one, even though you have other stuff going on. I'm trying to save you one more time coming back. It could be a whole nother day that you have to come back. To do that, I would have to get your consent to do this by video like we're doing right now, or I can go ahead and schedule you back to court at another day and you can personally appear. I'm just trying to save you another appearance. So to do that, you would have to waive your personal appearance on another date and consent to say, yes, let's do this now by video.
Okay, just yeah, do it by video then.
Okay,
Yeah.
are you clear on it, or is it still a little confusing?
Just do it by video.
Okay, all right. So the driving suspended is a class 1 misdemeanor that has a maximum fine of $2,500, 6 months in jail, and or 3 years of probation. That's the maximum penalty. There is no mandatory minimum, so the court has the discretion from 0 up to those maximums. What I can inform you of is there's no jail time being sought for this case, so you're not facing jail if you're found guilty at a trial later down the road, or if you plead guilty or no contest, you're not facing any jail time. Do you understand that?
Okay, I'm just wondering how is it driving on a suspend when you don't even have a driver's license? That's what I don't get.
Okay. I don't know. So I'm going to enter a not guilty plea because you don't understand that. So what we'll do is schedule you for a pre-trial conference, and that's going to be where you meet with the prosecutor. The prosecutor will discuss the case with you, provide you maybe the police report so you understand why there's an allegation of driving on a suspended, revoked, or canceled driver's license. And then you can proceed with your not guilty plea if you still wish to, and a trial will be set, or they may offer you a plea agreement, or the case could dismiss. Does that make sense?
Okay.
All right. All right, ma'am. So I've scheduled you for what's called a pre-trial conference on December 15th of 2025 at 9:30 a.m. The other thing is you have the right to hire an attorney. You don't have to hire an attorney, but you have the right to. This case does not afford the ability to have a court-appointed attorney because there's no jail time being asked of the case. Unless you can give the court a qualifying reason of why you need a court-appointed attorney besides I can't afford one, I need another reason, then I can take that into consideration for a court-appointed attorney. Otherwise, you have to choose to hire one yourself or waive the presence of an attorney. Do you understand that?
Okay.
All right. How do you wish to proceed regarding the attorney? Hire one, waive the presence of an attorney, or provide the court with a reason that you want a court-appointed attorney?
Wait, the attorney.
All right. So the same form that waived the personal appearance that we discussed in the beginning will have the personal appearance waiver that we did this by video. Remember when we were talking about that?
Okay.
And the same form will also have the waiver of the attorney. So it requires a signature for both of those waivers because we've done the arraignment. I entered a plea of not guilty for you. We've done that by video with your consent, waiving your personal appearance. And then now that attorney waiver portion. Okay, so that will require a signature. Do you have any questions about anything that we've discussed so far?
No, not currently.
Okay, so your release conditions are obey all orders of the court, do not commit any crimes, notify the court immediately if your address changes, do not leave the state of Arizona without permission of the court, do not drive a vehicle on a public roadway unless you're licensed to do so. Can you comply with those release conditions?
Yes, sir.
And you'll show up to court as ordered?
Yes, sir.
All right, we'll release you on your own recognizance. Do you have any questions now?
Nope.
Okay, that'll be all then.
Want to state your full name for the judge?
Yes, sir. This is Mark Lewis Gutierrez.
Thank you, sir. All right, sir, the state has alleged 3 charges against you. All of them are felony allegations. The first one is aggravated harassment under the domestic violence statute. That's a class 6 felony. Then there's 2 counts of drug paraphernalia that are also both class 6 felony. On those charges, you have the right to remain silent, right to counsel, and right to trial. I've scheduled you for a preliminary hearing on the 17th of November at 4 o'clock p.m. You'll get a copy of this so you don't have to try to remember it all. The preliminary hearing is to determine if there's probable cause to charge you with those crimes, not convict you, but only to charge you. If probable cause is met, your case will then bind over to the Gila County Superior Court. If it is not met, one or all of those charges could dismiss. Your release conditions are the following: obey all orders of the court, do not commit any crimes, notify the court immediately of any address change, do not leave the state of Arizona without permission of the court, do not contact the alleged victim in any manner, do not possess any firearms. I'm placing a $5,000 bond hold on you, so you'll remain in custody on those charges unless you post bond. Being that you're held in custody, sir, you have the right to a court-appointed attorney if you cannot afford to hire one. Can you afford to hire an attorney?
No, sir.
All right, I'll send you a financial questionnaire that'll ask you questions about your finances, and that will be submitted to the court. Also, because you're in custody on a felony, the prosecutor must file a complaint within 48 hours of the date and time of this hearing. It does not count weekends and holidays. Unfortunately, we're coming to a weekend. So on Tuesday at this hour, if they do not have a complaint filed, then you'll be released on your own recognizance without having to post bond or bail, okay? If they do file a complaint, then your attorney will be assigned if you qualify for them. They'll be made aware of your charges, aware of your bond, and be in touch with you about the case shortly thereafter. Additionally, every person that's held in custody on misdemeanor or felony has a bond review. So this will be sent to an attorney to review the bond to find if it's reasonable or not. If they determine it's not, then they'll request a hearing and you'll be notified of that. If they don't request a hearing, it will be presumed that it's reasonable. Do you understand that information, sir?
I do understand that, sir.
Do you have any questions?
Yes, I do.
Go ahead.
2 things is that, one is that I am on HIV life-saving medication I'm supposed to have every day. And
Okay.
I did bring a bottle in. It had 2 of my medications mixed together because one of my bottles spilled. I asked for that. I haven't been given that yet. And also, I need to be able to call my neighbor to see if she was supposed to pick up my medications, and of course, to see if she could bring them to me if the case I'm going to be here. And the other thing is that, sir, I'm not a flight risk. I've always shown up for court. I've always shown up to my appointments. I've never missed one. I've been paying my fines.
So let me give you the reason for the bond, and I'll answer your questions on the medication. So first off, the medication portion. When we're done here, speak to the detention staff. They'll allow you to use a phone call to try to make some arrangements to get that bond. The reason why you have a bond is there was a current court order where me or another judge told you no contact with the alleged victim, and allegedly you broke that request. So what that means to the court is no matter what we say, you're going to do what you want. That's what you're charged with and alleged.
Well, sir, she contacted me first.
Okay.
Several times. We've actually been back and forth together. Been back together like 4 times.
So,
probably since last.
Okay, so what I need to do, sir, is make sure I assist you in protecting your rights. So we don't want to argue the case now. Today's not the place for that, okay?
Right.
The law enforcement has investigated what you had to say, and they investigated what the alleged victim had to say, and made a determination to charge you with aggravated harassment under the domestic violence statute. So with the argument of all of that is at a later date. That's to make you aware of that. make you aware of the bond, okay? That's allegations. I've read the allegations of what it is. You might have a defense to it, and you're not guilty of it. These are allegations, okay?
But I have to sit in jail.
Yes, you do, because of their probable cause that they submitted to make a determination to charge you with that. Okay, but it doesn't mean you're guilty of it, but it is that's what
But I only wanted my birth certificate back in my papers and stuff, and she ignored me for 4 days.
Yeah, sir, you're trying to discuss the case and argue the case here, and I'm trying to protect your rights the best I can. You just want to throw details about it out. I really don't. Today's not the place to argue it. So the reason why I set the bond is for what I told you. There's allegations made against you. They're only allegations. There is that bond that is in place. Regarding your medications, just talk to the detention staff to be able to use the phone to get those arranged.
Thank you.
You're right, sir.
Keep going back.
You want it sent to you, or?
Man, I got it. Judge, if you would, send those to me.
Okay, all right.
Appreciate it.
You betcha. Bye now.
Bye.